Let's jump right into one of the most dramatic and precedent-setting true crime stories in U.S. judicial history. Welcome to This Explainer. Today we're unpacking the very first time a federal judge was impeached and removed from office. It's a truly heartbreaking and honestly fascinating tale of politics, mental decline, and unprecedented constitutional gray areas that really tested the very foundations of the newly formed United States.
I shall be sober tomorrow. I am now damned drunk. Okay, picture the scene. It's November 1802, right in the middle of a federal courtroom. The presiding judge approves a motion to adjourn, looks out, and shouts exactly that. It's absolutely stunning to imagine this happening in any court today, let alone in the super fragile early days of the American Republic.
And the man slurring those words? He wasn't some common rowdy defendant. He was Judge John Pickering, a sitting federal judge. This was a man entrusted with upholding the laws of the nation, a guy wielding immense power and responsibility. So you gotta ask yourself, how does a federal judge reach such a staggering public low?
Chapter 1. The Respectable Early Career.
To really grasp the tragedy here, we have to look at who John Pickering was before he lost his grip on reality. Young John Pickering wasn't always this chaotic, raving figure. He was actually a deeply religious patriot. In fact, he was a key framer who helped draft the New Hampshire state constitution. He famously called it his favorite child of his own begetting. He even served briefly as the state's top executive leader.
His early reputation was practically pristine. He was this highly respected jurist who genuinely believed the law was a tool to ensure equal treatment for absolutely everyone. And he walked the walk, regularly providing free legal counsel to the poor. His stellar record as Chief Justice of the New Hampshire Superior Court even earned him the ultimate endorsement, a direct appointment to the Federal District Court by President George Washington himself back in 1795.
But sadly, after years of diligent service, things took a dark turn. Pickering began suffering from severe nervous disorders and a lifelong, frankly crippling struggle with hypochondria. Over time, this tragic mental decline manifested in ways that the public just couldn't ignore anymore. He started exhibiting really erratic behavior, using rampant profanity, and most noticeably, he was frequently intoxicated right there on the bench.
Chapter 2. The Case of the Eliza. Now, this is where Pickering's private tragedy collides head-on with a massive national political firestorm. Enter the United States v. Eliza. The Eliza was a ship seized for allegedly violating revenue laws. Basically, they were accused of smuggling new cable into Portsmouth to avoid paying duties. Well, this seemingly local dispute over ship cables instantly blew up into a fierce partisan proxy war. On one side, you have the ship's skipper, Captain William Ladd, and the presiding judge, John Pickering, both Federalists. Squaring off against them was tax collector Joseph Whipple, who was backed by the broader administration of President Thomas Jefferson, the Jeffersonian Republicans.
During the trial, Pickering was reportedly highly intoxicated and just raving. When the Republican district attorney politely pointed out that the judge hadn't even heard the government's witnesses yet, Pickering basically ignored him. He blatantly ruled in favor of his fellow Federalist anyway, jeering from the bench, "You may bring 40,000 and they will not alter the decree."
As you can imagine, this crisis escalated incredibly fast. Appointed in 1795, Pickering was super diligent until about 1800, which is when he mysteriously started missing court dates. Then we hit that chaotic Eliza ruling in November 1802. Whipple was furious at the blatant favoritism and demanded the Jefferson administration intervene. By February 1803, President Jefferson took direct action, sending evidence to the House of Representatives and officially kicking off the impeachment process.
Chapter 3. A Constitutional Crisis.
You see, this wasn't just about removing a bad judge. Because of how the nation's founding documents were written, this situation brought the young republic face to face with a massive, literally unprecedented constitutional dilemma. The U.S. Constitution, specifically Article 2, Section 4, is extremely strict. It allows for the removal of a federal judge only for treason, bribery, or other high crimes and misdemeanors. That is the exact, limited constitutional language the founders settled on to protect the courts from political whims.
So here is the crucial, seemingly impossible question. Can mental illness be considered a high crime? I mean, how do you constitutionally impeach a man whose real issue is insanity? By definition, that's a tragedy, not a crime. The Constitution just didn't have a mechanism for removing a judge whose disabilities rendered him unfit. And Pickering, in his severely compromised state, absolutely refused to resign.
This created a totally fractured partisan dilemma. The debate split straight down party lines. The Federalists were terrified this impeachment was a calculated Republican plot to destroy judicial independence and upset the balance of power. On the flip side, the Republicans, who controlled the government, desperately needed to remove an unfit judge. They argued that mental incompetence and the resulting destructive behavior essentially equaled a high crime. Senator John Quincy Adams hit the nail on the head regarding the logical contradiction here. He noted the painful dilemma of deciding to remove a man on impeachment for high crimes, even though literally everyone knew he was simply insane.
Chapter 4. The First Judicial Impeachment.
The stage was officially set for the very first removal of a federal judge in U.S. history. This was a trial that would permanently stretch the boundaries of the Constitution. The dreary March 1804 Senate trial was wild, to say the least. Presided over by Vice President Aaron Burr, the whole thing actually proceeded without the defendant. In a truly heartbreaking detail regarding his phobias, Pickering was so terrified of crossing water that he wouldn't even travel to Washington to attend his own trial. Instead, he sent his son. His son had to stand before the Senate and tragically concede that his father was, in fact, mentally unstable. But despite the lack of a literal, actual crime, the Senate moved to vote anyway.
And the 1804 Senate verdict? It came down strictly along party lines. Out of the senators voting, 19 voted guilty. Every single one of them a Republican. 7 voted for acquittal, all of them Federalists. And just like that, this pivotal, guilty vote forever set the precedent that the impeachment process could, practically speaking, be used as a tool to remove an incapacitated, unfit judge. They basically bypassed the strict wording of the Constitution for the sake of keeping a functioning judiciary.
Now, there is a fascinating, almost poetic footnote to this whole saga. John Samuel Sherburne took over the role. If that name sounds familiar, it's because Sherburne was the very Republican district attorney who testified so strongly against Pickering during the whole ordeal. He was appointed to take Pickering's place on the bench, which, a lot of people thought was in pretty poor taste. But here's the twist. Years later, Sherburne would suffer his own tragic mental deterioration and senility while serving as judge. It was a fate some locals viewed as a dark judgment upon him for his role in Pickering's downfall. As we wrap up this explainer, I want to leave you with a final, provocative question to chew on. Where exactly do we draw the line between protecting judicial independence and ensuring accountability for those no longer fit to serve? The tragic fall of John Pickering forced a young nation to basically bend its own rules to solve a practical nightmare, and it left us with a delicate balancing act that we still navigate in our courts today. Thanks so much for exploring this incredible piece of history with us. Keep learning, keep asking questions, and I hope this leaves you wanting to uncover even more about the hidden stories of our legal system.